Okay, so this is a iTopixs video that summarizes some of the essential concepts for intellectual property. And what we're trying to do here is not necessarily, again, make you experts in intellectual property, but to give you a sense of the scope of protection and the differences between these different forms of intellectual property. And so IP is commonly refers to patents, copyrights, trademarks, trade secrets, and know-how. So let's run through some of the concepts behind these forms of protection. So patent protection, you hear this thrown about quite a bit, and I think it's often a misunderstood form of intellectual property. We're going to focus mainly on the U.S. Protection for these forms of IP. In the United States, in order to be granted a patent by the U.S. Patent and Trademark Office, the invention must satisfy these three requirements, three statutory requirements. The invention has to be new or novel. It has to have useful, meaning it's useful or has some utility. And finally, it has to be non-obvious. Now, the first two, novel and utility, tend to be pretty easy to satisfy. So most patent applications are not denied on the first two grounds. It's the third requirement, non-obviousness, which is often cited as a reason to either deny or restrict a patent application. And of course, it's always obvious once you know the answer to something. The answer is always obvious. I mean, you can imagine yourself doing a mathematics problem, you can't figure it out, but once someone shows you how to do it, it's oh, that's simple, why didn't I think of that? Now it's obvious. So the problem-solving aspect, or the sometimes arguing it as not obvious, can be an uphill battle with the U.S. Patent Office, because their argument is, well, that's simple, anybody could see that. But it is the most common ground for limiting or rejecting patent applications. Okay, so again, the patents are reviewed by, and decisions on granting, limiting, or denying are made by the U.S. Patent and Trademark Office. So this is a federal program, constitutionally authorized in the U.S. Constitution. There are no state patents, only federal patents. And the unusual thing about patents that many people don't understand is that patents do not give you an affirmative right to make, use, or sell your invention, but give you a negative right. What we mean by that is they give you the right to exclude others from making, using, offering to sell your invention. You do not get an affirmative right. And so one way of thinking about that is if you have an invention and you get a patent, and it's a basic patent, then you do have the right to exclude others because there's nothing else out there. But if your patent is somehow using something else which has already been patented, then you really do not have a right to make, use, or sell your invention without getting a cross license from the other patent holder. There are different categories of patents, but the two most common patents are what we call products and processes. And so many patents, they're either getting a patent on the product or a patent on the process for making the product. So just for an example, suppose Apple were to get a patent on its new Apple chip used in the iPad Pro, referred to as the A9X patent. The A9X chip. Well, you would get a patent on that particular chip and the design of that chip, meaning that the configuration and layout of the pads and the conductivity lines, etc. But that would be on the product itself. However, you can also get a patent for making the chip. In other words, we start with a silicon wafer that is, 12 inches in diameter, doped with arsenic to a certain percentage, and then we cut certain lines and we dope with boron with certain percentages, and we cook the silicon wafer at temperatures of some temperature, 1200 degrees centigrade, for 15 minutes, et cetera, et cetera. So it's the process by which the product is made, and you would get patents on, you can get it arguably on both the product and the process. And the term for patents is typically 20 years from the date of filing. And you can also get patents for design patents. It's a little bit shorter. That'd be 14 years. But the majority of patents are 20 years for product and processes, and that would be from the date of filing. Again, different types of patents. We see design patents, plant patents, utility patents. You cannot get patents on laws of nature. If you discover a law that describes how an apple falls from a tree, F equal ma, you cannot get a patent on that discovery. Or you discover the Schrödinger equation describing the solution of the differential equation, the solution of that being the electron orbitals, the 1s, the 2s, the 2p orbitals for an atom. You cannot get a patent on that. And algorithms are somewhat of an issue. There's a lot of creativity in algorithms, but it seems to be an evolving area that seems to be a little more favorably viewed. There are different types of filing systems, patent filing systems, and we call the two basically the big ones, examination versus registration. And of the two, the examination system is the stronger, and it's what we have in the United States and Germany and some other countries. But the key difference here is that under the examination system, the patent office will examine the substantive provisions of the patent. In other words, they will look specifically at what is being claimed as the invention and decide whether that is patentable or not based on the prior art that already exists. So they will search prior art, they'll search other inventions, they'll search whether your idea had been disclosed in a publication in Scientific American or Motor Week or something like that, and then either try to limit your invention or by narrowing the claims or simply reject the application. And this is in contrast to a registration system in other countries like France, where you simply file your patent application and nobody really looks at it. They simply record it on the date it was filed. So there's no real substantive review of the patent. So it's a very quick process. And the way it works then, if somebody claims, or if you later claim someone's violating your patent, then that's when they will examine the substantive merits of the invention. And that's when they fight it out. So you could see, in one sense, it might be a more efficient use of resources because you're only going to examine the patents that the owners claim are being violated. As opposed to the U.S. system, everything is being examined. Now, in the U.S. system, we did make a change in 2013 to a first-to-file system, meaning that they still look at the substantive provisions, but now if someone else files another patent where you're trying to figure out who was the inventor of this thing, because they both filed the same invention and they're arguing, well, who came up with it first? And actually the invention of the laser was a classic case for that. Gordon Gould claimed he was the first to invent the laser, and he had to fight it out with Charles Towns, who was a professor in the United States. They had to determine who was the first to invent. The U.S. doesn't use the first to invent anymore. and to resolve that factual issue, they would have it set up an interference where the two inventors would come in and show facts who was the first to invent the laser. But now, if that comes up, the interference proceeding is simply used to look at who filed first, who was the first one to make the filing, who was not the first to invent. So now it's more like a race to the courthouse. Who was the first to get there? So if you've got something, you want to get it filed as quickly as possible, because if someone else later claims they're the inventor, the first to file will be the winner. So we call that first to invent, FTI, or first to file, FTF. And it applies to patent applications filed after March 16, 2013. Okay, so if you file in the United States and then you want to file in other countries, how does that work? And just to be clear, the protection you get from a patent is geographical. If you get a patent in the United States, you can prevent other people from making, using, selling, offering to sell your invention in the United States. That right terminates at the boundaries of the United States, the same for Germany or Argentina or India or Russia. So if you want protection in other countries, you have to file for protection in those countries. And generally under the treaties, you have roughly 12 months from the date of filing in the United States or the other country to file in other countries participating in that treaty. So if you file in the United States on January 1st, 2016, then you should file in all the other countries you want protection in no later than 12 months after that date. Now, if once you file and once you get the patent, then you have the right to protect your idea or prevent others from making, using, selling it in that country. But if you don't file, then you don't have any rights to exclude others. So what's the issue here? Well, if you have a patent on an industrial laser, for example, an industrial laser is pretty much going to be used in the industrialized countries, so in the manufacturing processes. So, you want to file in countries that have industrialized manufacturing processes that would use a high intensity laser. But, if you're probably not going to be using a high intensity laser to manufacture things in Burundi or Somalia. So you probably are not going to target IP filings in countries like that. Now, if they make that high intensity laser in that country, and then, which they'd be allowed to do because you don't have any protection, and now they ship it to Germany or United States or Canada, then you would stop it at the border. You'd notify customs that this is a patent infringement under the U.S. patent, and they would stop it from entering the borders of the United States, because that's where your legal protections start, at the boundaries of the country where you have a valid patent. So this is Monsanto's an interesting case. So here they had a plant patent on certain soybean seeds that had certain desirable qualities. And the issue here was that the farmers would buy the soybean seeds and then plant them, and then they would harvest the seeds from those plants, and they would stop buying the seeds in the store that were covered by the patent. And the question is, did they have the right to use those seeds that were the offspring of the plants that they had legally purchased? And so it says there, the question in this case is whether a farmer who buys patented seeds may reproduce them through planting and harvesting without the patent holder's permission. And the answer is, we hold they may not. So the patent holder gets the right to the seeds that are the offspring from the parent plant. Okay, so the other another form of intellectual property is copyrights. People tend to be somewhat familiar with this. The Copyright Act of 1976 made a number of changes, and it covers what we call original works of authorship fixed from the moment of creation and fixed in any tangible medium from which the works can be perceived, reproduced, or otherwise communicated directly or with the aid of a machine or device. So it has to be an original work, it has to be fixed in some tangible medium, and the rights attach automatically from the moment of creation and fixation in the tangible medium. So in other words, once you create it, you have the rights. You do not have to file anything. You don't have to file anything with the Copyright Office. Those rights vest automatically. And a lot of people are a little surprised to hear that. Now, oftentimes you will give notice of the copyright. I mean, you look at the bottom of the slide, there's a copyright notice with a date and my name. And, you know, it's not required, but the point is it now gives notice that, you know, that this is copyright and I own it. And if you want to use it, you have to get permission from the author, which would be me in this case. So it's not required, but it protects the author from these works being out there and used generically, or an argument being made that the author has abandoned his rights to that creation. So again, no obligation to do any filing. You get exclusive right. You do get an affirmative right to make and print and use your creation, as well as derivative works. So if you write a novel, and then someone wants to make a movie of the novel, then you have those rights because the movie is derived from your original work. They say that, so the question is, what is the protection you get from a copyright? Well, the words that we say is that the copyright protects the form of the expression and not the idea or subject matter. So what that means is, for a patent, you're actually getting protection on the idea itself, the creative idea itself. But with a copyright, you're not getting protection on the idea, you're getting protection on the expression of the idea. So if you take a picture of a sunset and somebody likes that picture, nothing really prevents them from going out and taking the identical picture, placing their camera in the same location, and hopefully have the same cloud formation, etc., and create their own picture. They would be the original author of that picture and would have their own rights, even though it may look identical. So that's the point. You can create it yourself because copyright protects the form of the expression, not the idea of a picture of a sunset. And the term is 70 years after the life of the author. So, and this applies to most copyrights. So Mick Jagger writes a song, for example, Satisfaction or Sympathy with the Devil in 1965, and he's still alive at roughly whatever it is, 70 years old. So he has a copyright for his life plus an additional 70 years. And that is generally the term for most copyrighted works. This is interesting from China, the China website for the Ministry of Commerce and Finance. They actually claim a copyright on the articles posted on their website, and which is kind of interesting because the United States does not claim a copyright for things posted on U.S. government websites. The argument being these belong to the people and the government is not restricting use of this kind of public information. But here, interesting that MOFCOM is asserting a copyright. Okay, so let's look at trademarks, trade dress, service marks, and a trademark or a service mark is a word, a name, a phrase, or symbol used with products or services to identify the product or service and distinguish it from other products or services. And the primary purpose is to identify the source of the product and distinguish it from other products. And here you get both a combination of federal and state protection. So you can do federal filing, or you can just rely on state protection. So you have a dual regulatory schemes in this area. And like a copyright, you do get rights to affirmatively use and protect your copyright. And the argument here is if someone else is using the trademark, if someone else creates a trademark and you claim it infringes on your trademark, then the question is it confusing? Is it confusing the source of the products? Because the idea is to protect the source of the product, the reputation of the product. And the term of protection is you've got it basically as long as you've not abandoned it, you've not walked away from it, and you pay any user fees associated with it. So here are some well-known common copyrights. The M from a McDonald's Arches, the rainbow apple, the Exxon sign and double X. Donald Trump got a trademark on his campaign slogan, Make America Great Again. Here the shape of a Coke bottle or the shape of a building can be a trademark. Here's Donald Trump's his application, or actually it might actually be the grant, Make America Great Again. Rolex is a well-known trademark. Copyrights on designs of buildings since 1990. Here is the design for an Apple store. If you've been to an Apple store, you see the glass floor to ceiling or some part of the ceiling, the openness of the store. Here's a trademark on an Apple building design. And here the European Union High Court grants a trademark for the Apple store design. This was granted just a couple of years ago. And they now have valid trademark for building design in Germany. The European Court of Justice overruled how the store design is a valid trademark. And here is a store design for Microsoft. And it's right here in Tyson's Corner, McLean. And so you might ask yourself, is there any similarity with this kind of glass from floor to ceiling, some point tables? You might ask yourself, is that a violation? I mean, could you be confused walking into that store, thinking you're walking into an Apple store? An active area has been color. Whether color by itself can be a trademark. Can you get, if your employees wear red jackets or red shirts, can you identify that color as a trademark? And generally the answer is no, you cannot get a trademark on color by itself unless it has obtained some other secondary meaning. It's a little surprising. Tiffany has a trademark on their blue box for their jewelry. It's a distinctive shade of blue, was chosen for Tiffany boxes, shopping bags, and catalogs. It's universally recognized, and it is a shade that has made Tiffany famous. And here's our trademark. And here, Cadbury chocolate wraps their chocolate in purple, and that has long been identified as something associated with Cadbury chocolate, but in fact, the UK Court of Appeals overturned a lower court and validated the trademark, states it lacked the required clarity, precision, self-containment, durability, objective to qualify for registration. So they lost, in UK, Cadbury lost their famous purple color as a trademark identifying their chocolate. Tiffany, of course, is well known for its jewelry and settings, and Costco was selling, it's a club that requires annual membership. They're here in the Washington area. You benefit from lower prices. They sell diamond rings, gold bracelets. And Tiffany sued Costco a couple years ago for using a Tiffany trademark for diamond rings, saying Costco was not licensed to use the Tiffany trademark, and they were selling no brand name rings but described the diamond setting as a Tiffany setting. And they claimed this was a trademark violation, and they sued them. Tiffany lost. So, as I was saying, Tiffany sued Costco and for trademark infringement, and they lost. The court ruling that Tiffany's setting was a generic term, and Tiffany had no protection in that. Trademarks can be either registered or unregistered. You do not have to register your trademark. If you simply want to use it, you can start using it. It's just that you cannot use the common symbol you see, R, with a circle around it, because that is restricted for copyrights that have been filed and registered with the U.S. Patent, Trademark, and Copyright Office. So, and it actually is a violation, and in some countries, criminal violation, to use a registration symbol like that when in fact it is not registered. But you can claim a trademark simply by using it and putting TM. Where you would put the R in a circle, you put TM, you're claiming the use to that trademark. And if you have an intent to use a trademark and you want to protect it from someone else, you can actually file an intent to use application, and protect it while you organize your business or whatever it is that's, delaying your actual use of it. State marks or common law rights use the TM or the SM for trademarks, and service marks normally do not require any filing. You just claim it. And the mark gives a register mark gives constructive notice that it is registered. So it does give you some additional protection by registering with the federal government. But as I said, in some countries, using a registration symbol when it's not registered can be a criminal offense, such as Germany, Brunei, India, Korea. The strength of the trademark, there's a spectrum here. And the strongest trademarks are the ones that are fanciful and made up. So Exxon was never a word until Exxon made it up and used the double X to identify its company and the source of all the products and services. So those would be the strongest. The next strongest would be ones that are somewhat arbitrary. So Amazon as a bookstore has nothing to do with the Amazon River in South America, has nothing to do with Amazon women. They chose Amazon as a word to use to describe their online, originally a bookstore. Next, strongest or weakest would be names that are suggestive. So like Champion Sporting Goods. If you buy your sporting equipment here at our store, you will be a champion. So it's suggestive of an outcome. Next weakest, if you will, would be descriptive. So U.S. News and World Report, it's describing the magazine. And it's a fairly weak trademark because it's descriptive. And finally, the weakest are ones that are generic. And they just don't mean anything. So you really have no rights in that. And that is the fear that, someone who has a protected trademark will eventually, the public will use it in a generic sense. And Xerox would be an example. Xerox, again, what kind of word is Xerox? Before Xerox identified it with copying. And then people started using it as a verb. Would you Xerox this for me? Meaning, would you copy it for me? So Xerox tried to inform the public and protect its trademark by telling people, don't say that. And, it has become really a kind of generic term for copying. Trade dress is a type of trademark, and it identifies physical details and design on a product or packaging which is not functional. It cannot be functional. It is something that is used to dress up the product, to identify the source of the product and distinguish it from other products. And it can be a word, name, symbol, device, or combination. And the same thing for a service mark. To identify and distinguish the services of one person, including a unique service from the services of others, and indicate the source of the services. Or to identify the goods. So the identical language. So the trade dress, it has to have it has to be distinctive, have some secondary meaning, and sometimes color can be trade dress. We'll talk about that a little bit. But it goes essentially to the total image and overall appearance of the product. Can include colors and shapes, design. But once it becomes functional, then it no longer is trade dress. So here's a question right here. Claritin for allergies, and the CVS brand, which is essentially the same active chemical component. You see the similarities with the blues and the whites and the reds, and the packaging is non-functional. It's basically the way you make the product look. Same thing for Zyrtec. You see the color green, white, and red. Hand lotions. Here you see Vaseline and Walgreens. Same kind of tan brown color with the blue. Same thing for this Vaseline product. And the question is whether this, these colors and shapes and everything are non-functional. So arguably trade dress, but the question is whether the copy is causing confusion in the minds of consumers. Cough medicine. Walgreens calls it Waltussin as opposed to Robitussin. Energizer batteries, Walgreens products. So the functions of the trade dress is that, again, functionality is critical. So if you have a sash around a dress and you claim trade dress for that design, the problem is the sash serves a function. It tends to pull in and gather the dress around the waistline and accentuate the waistline. So something like that would not be trade dress. And other factors to consider: is there an expired utility patent? So if it's utility patent, that means it had a function. Advertising and somehow promotes the utilitarian advantages. And whether this particular design has advantages over others, that all goes to functionality. But again, the key here is, what's the likelihood of confusion in the minds of consumers? Are people confused when they see the labeling and packaging and advertising? Okay, trade secrets is another branch of another category of intellectual property. There's no federal law on this. It's all covered by state law. And it's a very flexible concept. It's not easy to define. But here you see in the state of Virginia, any information, which are formulas, patterns, programs, devices, that derives independent economic value, whether actual or potential, from not being generally known to others and not being readily ascertainable by proper means. So, no filings for trade secrets. Again, the key point is that the information is not generally known or derivable by legal means. And it has value because it's a secret. Nobody else knows it. And clearly, if the secret becomes public, then it doesn't have any value. It loses its value. And the term of protection is indefinite as long as you safeguard the secret. So the formula for Coca-Cola soft drink, the composition of sugars and syrups, etc., is a trade secret. The spices used on Popeye's chicken, for example, could be or is a trade secret. What is a blend of cayenne pepper and flour, etc., to give those flavors? So here's a comparison between trade secrets and patents. You can see there is no disclosure for trade secrets, but for patents, this is, the disclosure is the quid pro quo with the federal government. You disclose what it is to the public, and you get a monopoly, a fixed term of 20 years from date of filing to prevent anybody else from using it. But there is a fixed term, 20 years. Here it's indefinite if you can keep a secret. And sometimes this is better for technology that is rapidly changing. It's not worth going through a disclosure process, not worth going through a whole prosecution process for a patent. If it's going to lose its value in 1 or 2 years because the technology is changing so quickly. Examples of trade secrets: customer lists, price lists, manufacturing processes, how long you cook French fries in peanut oil at McDonald's, at what temperature and how thin or thick the French fries are cut, pricing information, details of your bidding processes. All of these could qualify as trade secrets. So know-how is a kind of a close relative of trade secret. It's very difficult to define, but it's basically a kind of like how your business works and who you have relationships with and the banks you use and your supply chain and who supplies your hamburger buns or who supplies your aluminum and your pricing terms and who your customers are. And it's the kind of things you would learn. For example, you sign up for a franchise for Burger King or Big Mac or McDonald's. They show you how to run the business, how to make the burgers, the fries, the structures, and not necessarily patentable, probably a trade secret if you take appropriate steps, but basically confidential. The idea to keep it out of the hands of the general public as much as possible. No filings. You certainly can sue a former employee if they're unauthorized disclosure of the information, and usually they will have you sign, a non-disclosure agreement. And we've discussed this when we looked at non-disclosure agreements and non-compete, non-circumvent agreements, where they attempt to define confidential information. And the term of protection is indefinite, basically. Other questions that come up: who owns what when things are created for hire? So you hire someone to paint a painting for you. Who owns that painting? Well, technically it's the person who created it. So you want to address this question in your contract. And certainly employers are going to require employees to assign any rights to the company to anything that has been developed on company time. And this actually was an issue in one of the sitcoms over the summer involving a Silicon Valley startup group. The question being who developed a software. When he developed the software, did he use any company facilities, or did he do it on company time, or did he do everything on his own? So here's a question you might think about. Apple's fingerprint technology on their iPhones and iPads. What about the software for that? What would be the appropriate protection for that? Should it be a patent, trademark, trade secret, copyright? And the answer is probably a trade secret. Probably the last thing you want to do is disclose it, because then people will hack it. And so you probably want to do trade secret protection for something like that. All right, that's the end of this video.